Thank you. We recognise we have three things on our homework list, which I'm sorry I can't quite give copies to the court at the moment. One is the relevant parts of the court report. I saw.
It's not all that helpful.
I've
had a look at it.
We've got the bit we cited before the judge.
Which bit do you think is?
My only concern is there may be more. Just, I mean, shall I hand up copies of what we have?
Yes. Just give me the numbers. I mean, the recommendations are at paragraph. Have you given it to Mr. Nash?
No, it's coming now. I'm so sorry.
1285. It's just, it looks at it very much through the lens of you know, the old Bankruptcy Act. You know, it shows how much one forgets. I've completely forgotten all the twists and turns of the Bankruptcy Act. One of the main recommendations is that it should no longer only be men whose dispositions are avoided, it should also include women, which is quite remarkable.
I'll show the age of the document.
It does, it's quite remarkable. Yeah.
The bit that we've just handed up, we'll send electronic copies as well and work out whether there's anything else, is the bit that was cited to the judge, which is chapter 28, where Sir Kenneth Court discusses the recovery of assets by the debtor. And in that extract between paragraph 1200 and 1209, the distinction is made between what is now 423, going back to the Statute of Elizabeth, and the new provisions that are being brought in. And I think that was the focus of the court's questioning this morning.
It was 172 of the Law of Property Act.
Precisely. And one sees that at paragraph 1202, where the principal remedy is discussed there. 1208 shows the focus of the new provisions. So the second column, 1208, in the present chapter we shall be concerned with transactions voluntarily initiated by the debtor himself. Such cases fall into two classes, and A is, in shorthand, transaction at an undervalue, and B is, in shorthand, preference.
239.
Precisely, so what becomes 238 and 239. And then one sees in 1209 the statement, the statutory provisions dealing with such transactions, i.e. what becomes 238 and 239, are directed at an altogether different objective from that at which section 172 of the Law of Property Act and Statute of Elizabeth I, which preceded it, were directed. In other words, what is now section 423. The latter, namely 423, were designed to protect the creditors from fraud. The Bankruptcy Code, on the other hand, is directed towards achieving a pari passu distribution of the bankrupt's estate among his creditors. The justification for setting aside a disposition of the bankrupt's assets made shortly before his bankruptcy is that, by depleting his estate, it unfairly prejudices his creditors, and even where the disposition is in satisfaction of a debt lawfully owing by the bankrupt, by altering the distribution of his estate, it makes in a pari passu distribution among all creditors impossible. So that's the goal. And apologies, I made it by abbreviated shorthand this morning saying it's to protect the pari passu principle. This was the extract we cited before the judge for that proposition.
Yeah, thank you.
We will check overnight if there are other parts of chapter 28 which are relevant. But this is what we thought was the most important last time round. And the share sale agreement will send the whole copy. It is missing a couple of pages at the back, including things such as governing law and entire agreement. So we'll make sure that finds its way to the bundle.
What is the governing law?
The governing law is England and Wales,
Right.
with jurisdiction of the courts of England and Wales. And then the third is the Delaware provision, which we will, if I may, I'll make a few points about the Delaware point now, but we'll make sure the provision makes its way into the bundles. Now on the Delaware point, if I may, having reflected over lunch, we make two submissions on the point. First, if we were right about what I described as the unnecessary cash removal point this morning, then the Delaware point doesn't need to arise and doesn't need to concern the court. And just to unpack that a little bit, if we're right about the unnecessary cash removal point, then it believes there are no reasonable grounds for believing that the transaction, whether it's the dividend or the wider transaction, of which one element was the dividend, would benefit UK CS8. And that's because it's never been suggested that FOIGC was unwilling to buy UK CS8 unless the cash was first removed. And I think it was my Lord Justice Newey who this morning pointed out that no purchaser would say that. So the learned judge didn't grapple with the answer to the Delaware point, and by answer I mean whether the dividend was also unlawful as a matter of Delaware law, because she found that a cash-free and debt-free sale is commercially reasonable, and the defendants weren't told that it would be unlawful as a matter of Delaware law. So that's where she went. Now, if our point we made this morning succeeds, though, we don't need our separate appeal against the Delaware law conclusion, because that's a separate attack on the judge's findings. But putting it another way, it doesn't help my learned friends, because even if the defendants reasonably believed that the dividend was lawful as a matter of Delaware law, in other words, we lose that part of our ground too, of course it doesn't follow that the statutory test is met, namely that they reasonably believe that it would benefit UK CS8. And the test under the statutory defence is concerned with whether the transaction was objectively beneficial to UK CS8, and therefore even a lawful dividend will fall within 238 and will not benefit from the statutory defence if it was not objectively beneficial. So that's why in her judgment, maybe I can show the court how the judge did that. Paragraph 265, which is core tab 7, page 201. So in reasonable grounds, the judge deals with Delaware law as a standalone point first, and then deals with our cash removal point second. And the judge deals with it first because, as identified within 265, we said that if the dividend was unlawful under Delaware law, that's a knockout blow to the statutory defence, and you don't need to go on to consider the cash removal point. The judge said at 267 that raises a difficult issue of Delaware law. The judge sets out the issue. The judge...
Which side expert was Professor Hammermesh?
That was our expert. So the judge indicated a indicative preference for our expert's view on the ratification point. But at 267, the judge noted it's a difficult point, and although I'm inclined instinctively to prefer Professor Hammermesh's view, there was no ratification on the facts of this case. But then, however, while it may have been necessary to reach a conclusion in the context of the claim for unlawful means conspiracy, it's not a task which is necessary for me to undertake in the context of the statutory claims. And the reason for that is what follows is the judge's finding that it can't be suggested that Mr. Mazzagatti or Mr. Dominus should have had the finer points of Delaware law at their fingertips, and then over the page, no reason to suspect the dividend was or might have been unlawful as a matter of Delaware law. So the case below put two different ways on limb 3. We said number 1, it's not to satisfy because the dividend's unlawful. You can stop there. Number 2, even if we're wrong about that, it's not satisfied because of the point we were discussing this morning. Now, the obvious point to make is merely the judge doesn't conclude the dividend was lawful as a matter of Delaware law. But even if the judge had reached that conclusion, that would not have assisted the defendants on the statutory defence. And what I mean by that is we know from Sequana that we looked at this morning, even where a dividend is lawfully declared, it can still be clawed back, in that case, under section 423, as a transaction at an undervalue. And in that case, even though the dividend was lawful as a matter of English law, it was clawed back because there was an undervalue and the purpose of moving the assets away from creditors. So similarly, in the current case, the mere lawfulness or otherwise of the Delaware dividend doesn't help the defendants. If it was unlawful, then it's obviously an end of the case for us. But lawfulness one way or the other doesn't help the defendants. And just to be clear, having checked, the defendants have never suggested that a defence as to Delaware law gives rise to a positive defence under 2385. Not in the defence, not in the respondent's notice, and therefore not one that they took. So that's why the judge goes through it in a staged analysis. Delaware dividend first, then cash removal second. Now I hope that sets the context of the Delaware dividend point. I mean, the court has our written submissions on why...
Sorry, you said there were 2 points on Delaware law. That was the first. You're coming on to the second now.
My lady, you're quite right. My second point, I forgot to say second before I moved on to the point that Sequana demonstrates that even if it was lawful...
So the second point was Sequana.
Thank you.
Okay.
We, of course, in our grounds of appeal and our skeletons still maintain that it's a freestanding reason why one can go behind the judge's decision on reasonable belief. However, we don't need to get there if we're right on the point we were making this morning. Otherwise, limb 2 and limb 3 of the statutory defence, noting the time in the court's indications this morning, we've tried over the short adjournment to cull what we were going to say. Subject to the court, we recognise that the fight, as indeed both parties have aimed in their skeletons, is likely to be on limb 3, reasonable belief, and we have the submissions on limbs 1 and 2 in our skeleton argument. But unless there are any particular points the court wished to raise, I wasn't going to spend time on them orally.
Well, I have this point. When you read the whole of the judge's judgment, as I think I said at the outset, she accepted the evidence of the defendant's witnesses, I think it would be fair to say, fairly comprehensively. And she makes findings of fact that they're telling the truth, that they genuinely believed that there was a real prospect of the debt being paid, and this was the best option, and that the transaction was always intended by all involved, and one can extrapolate to include UK CS 8 as being part of everyone thought, and the whole transaction is what you look at. So even if you look at the dividend itself, having accepted all those pieces of evidence, and they're almost too numerous to mention, but they're you know, in the 180s and then on into the 240s and 50s, it's very hard to see, if you take all those findings of fact at entirely face value, right, why she was not entitled to find, based upon that, even assuming that the transaction to look at was the dividend alone, why she was not entitled to find, bearing in mind all her findings as to the integrity and bona fides of the directors, that at the time it made this transaction, there were reasonable grounds for believing that there would benefit the company, because this was the company's best chance of getting the management separated, getting the conflicts of the past behind them, rather than drawing down on the loan of 250 million or finding other funding for the 120 million. There were indeed reasonable grounds for thinking that the transaction, even the dividend, which was just part of the apprehended arrangement, let's assume, because that's what she found, would benefit the company. And you don't have to show that it's definitely going to benefit the company, only that you have reasonable grounds for believing, and all that good faith, if I can put it that way, could reasonably have led them to think that subjectively, but also could give rise, because it's all true, according to the judge's findings, all fair and reasonable and normal commercial practice. And what I'm asking, which I think is the thing that really troubles me about this case, is why doesn't that follow almost as night follows day from her extensive findings? And if we have to accept all those at face value and are not faced with a claim that this was perverse and the evidence shouldn't have been accepted and so on and so on, even bearing in mind it's an objective test, why doesn't it follow on the basis that this was her assessment of the, if you like, the validity of the deal that was done, the commercial validity, which is, I suppose, a matter of fact on one analysis?
A number of points. I will repeat, I fear, some of what I've already said, but one is focusing on the position of UK CS8. That's what one needs to do under the statute.
Yes.
We say that before the judge gets into the detail of the evidence, she's asking herself the wrong question as a matter of law, and one sees that from the way in which she essentially says 423 and 238 are the same side of the court.
I'm sort of
Except
putting the
well.
question on the premise that you're right about that. That she gets the wrong question, but nonetheless she should have been asking this from the point of view of UK CS 8, and she should have been looking at it only from the perspective of the dividend, but the dividend as part of a completely plain vanilla, commercially sensible, indeed advantageous transaction for the group. Now, I mean, and you're selling on a debt-free, cash-free, whatever it is, basis, and blah, blah. I mean, I'm taking everything she says at face value, because when you read it, it's quite striking, right? It's not, this is not a sort of one, this is not a two-sided judgment. It's really a fairly one-sided judgment in favour of the defendants. Their evidence was pretty well accepted, lock, stock and barrel. Now, in that event, what I'm asking is, why wasn't she entitled to go with her acceptance that this was a plain vanilla sensible commercial deal, which involved a dividend, but that didn't matter because it was just part of the way it was understood to have always going to be, and because they behaved with absolute integrity, it sort of then goes into the equation of whether it was reasonable objectively. I mean, I think it's the way that Mr. Nash will put it. I mean, even if he's wrong about his main argument, which I say nothing about.
And the reason we say that still we prevail in that event is, as my lords indicated, Lim 3 in particular, is an objective standard. We are in fact relying on the findings of fact of the judge on why the dividend took place, and that...
When you're picking out 2 or 3 findings of fact, aren't you? The finding of fact that it was an afterthought and that the deal would have gone ahead effectively without it, without taking the 80 billion away, or could have done in theory. But there are many findings of fact that actually bank, if I can put it that way, the integrity of the transaction. I mean, you know, we have expressed a considerable amount of scepticism about that this morning, but let's assume that that's not really, as I suspect Mr. Nash is going to wag his finger, metaphorically of course, at me, and say I'm not allowed to allow my own commercial judgment to get in the way when the judge has given, she's a commercial judge, she's imposed her commercial judgment, and if it is true that this is a transaction of complete commercial integrity and a usual transaction, you haven't challenged that finding, and that's the end of the matter.
And the problem, we say, there with the judgment, and the problem for the statutory defence, is that the judge does not grapple anywhere within the reasoning in relation to what we called this morning as the cash removal point.
The right question.
Exactly. And what the judge doesn't ever ask herself in the judgment is whether on a sale of these terms, which did involve the removal of cash from an insolvent company, was one which should avail itself of the statutory defence, against a backdrop of her finding that the reason why the dividend was declared is because old parent wanted to extract the money.
And in addressing all these points, you're assuming, are you, that you've lost on ground 1?
My lord, yes, I thought that was, I'm so sorry, I thought that was the premise of the question.
As I understand it, you say, well, if you were you to win on ground 1, then actually the judge hasn't asked that question.
Precisely. The judge hasn't asked that question at all.
But if you lose on ground 1, it's a unitary transaction for which there is very good commercial justification. But you say, well, even so, what she found was that the old parent wanted to extract the money at the last minute and didn't need to.
So, well, precisely. So we say, at a broad grip level, there was commercial justification. That is what the judge describes as commercially understandable but entirely reasonable, namely that old parent wanted to take the money out. We say that doesn't engage properly or at all with the statutory question, which is, from the perspective of UK CS8, why was that reasonable?
Yep, okay, well, thank you.
Subject to the court, that's grounds 1 and 2.
Yes.
I think Mr. Venkatesan has a few points to add on ground 3.
Thank you. Mr. Venkatesan.
I'm grateful, my lord. We have reflected on the indication from the court this morning about how ground 3 should be addressed. And subject to one procedural point I ought to raise with the court, I think I can therefore take it quite quickly. Can I begin by identifying that there are actually two distinct points within ground 2? One a point of law and one a point of fact. So just taking it in stages, as the court is aware, ground 3 concerns Rockrose's decision to write off a debt of £39 million, which was owed to it not by UKCS 8, but by a different entity, UKCS 9. And at trial, the case advanced by the respondents was that the debt, although owed by UKCS 9, was rechargeable to UKCS 8, and therefore the discharge of the debt benefited UKCS 8 and had to be brought into account in ascertaining the extent of the undervalue. The learned judge accepted that submission, and we respectfully submit that there are two separate reasons why she was wrong to do so. One a point of law and one a point of fact. And the two reasons are these. First, even if as a matter of fact the 39 million debt was rechargeable to UKCS 8 as the learned judge found, even on that premise, that is, we submit, irrelevant as a matter of law. And second, the debt was in fact not rechargeable to UKCS 8 in its entirety. That second point I don't shy away from recognizing is a challenge to a finding of primary fact, and I'm mindful that this court rarely interferes with findings of primary fact made by a trial judge, nor do we dissent from the observation of my Lord the Master of the Rolls that the factual issues are quite complicated relating to the pension point. But what I propose to do with the court's permission is to deal first with the point of principle, which has nothing to do with the facts, which is closely related to ground 1 in any event. The points of law the court will deal with in any event. And it raises a point of principle about the concept of consideration under Section 238 of the Insolvency Act. Can I invite the court, please, to go back to the provision which we've looked at? It's Authorities, Volume 3, tab 27, page 996. So looking again at subsection 4.8 towards the bottom of the page, and the court has seen this, but it uses the words on terms that provide for in the second line of subsection 4.8. So it says, the company makes a gift to that person or otherwise enters into a transaction with that person on terms that provide for the company to receive no consideration. We submit, and I will develop this in a moment, but we submit that the effect of those words, on terms that provide for, is that consideration received by a company can be taken into account under Section 238 only if the terms of the transaction provide for the company to receive it. So to put it another way, my lords, my lady, it is not enough, we say, that a company as a matter of fact receives some benefit for entering into a transaction. It must be shown that the terms of the transaction, I don't say expressly, it can be a term that exists as a matter of construction or implication in the usual way, but we do say that it must be shown that the terms of the transaction provided for the company to receive that benefit.
You're going to have to deal with Bruin Dolphin.
I do, yes. Well, we actually say that Bruin Dolphin supports us on this point, but the authority I wanted to begin with, if I may, Sequana, where the point, so far as we are aware, it's the only case directly to deal with the meaning of the words on terms that provide for.
And just thinking ahead, I mean, on its face, this is dealing with whether there is a transaction at an undervalue. And here the judge found there was a transaction at an undervalue. So I assume you're going to proceed from section 238 through to section, whatever it is, 241,
Yes.
to say that that informs what should be done under 241 as well.
Precisely so, my lord. And the reason I propose to do it that way is that, as your lordship says, the learned judge accepted, and indeed this was common ground, that whether you take the pension into account or not, there is a transaction at an undervalue. But the learned judge finds, and I'll take the quote of the passage, that it affects the extent of the undervalue, and the extent of the undervalue will in turn affect remedy. In short, if I'm right about this legal point, then even if the pension debt, the discharge of the pension debt, factually benefited UKCSA, that would be irrelevant. And so then the extent of the undervalue would simply be the face value of the dividend, which is 84 million. And one wouldn't get into the factual questions about was it in fact rechargeable or not. But I recognize I need to deal, as my Lincoln pointed out, with Brewin Dolphin. Sequana, which is the authority I wanted to begin with, is at volume 2, tab 16, page 405. The first point I make about Sequana, which of course the court has already looked at, is that the creditor in that case, BAT, was advancing two different arguments. The first was that the dividend paid by the company in that case was a gift within the meaning of section 423. And the second was that the dividend, even if it wasn't a gift, was a transaction on terms that provided for the company to receive no consideration. And one can see these two distinct issues identified in a passage we looked at this morning, para 35 at page 415. If I could ask the court please to go back to that, page 415. So the second sentence of para 35 identifies issue 1. The first is whether a dividend is a gift within the meaning of 4231. And then issue 2 is identified just above letter G. The second is whether, if not a gift, a dividend is a transaction on terms that provide for the payee to receive no consideration. And issue 3 doesn't matter for present purposes. Now, what is important about the Sequana case in our submission is that Lord Justice David Richards decided issue 1 against BAT, but issue 2 in its favor. And just to explain that, if I could invite the court please to look at para 37 at the bottom of page 415. This is where the Court of Appeal begins its analysis of the gift issue. At the bottom of the page and then over the page, the court notes the submission of leading counsel for Sequana, that if the dividend was not a gift, then that supported Sequana's case that for the same reasons, it was not a transaction for no consideration.
So which paragraph is that?
37, my lord, at
Yep,
the bottom of 4 and 5 through to the following page. So, and then at para 38, the Court of Appeal recorded Sequana's submission that the reason why a dividend is not a gift is that it is a return on the investment that the shareholder or the original subscriber to the share makes when they buy the share. One can see that between letters B and C at page 416, para 38. So just taking stock, the argument Sequana's running in this case is that a dividend is not a gift because the company did get something in return for it, namely the shareholder's original investment. And for that reason, it cannot be a transaction for no consideration either, because of course what the company originally got is consideration. Now at paragraph 41, at the bottom of page 416, Lord Justice David Richards accepted the first limb of Sequana's case, namely that it is not a gift. In my judgment, Mr. Rabinowitz's submission is correct. For the reasons he gave, rights are conferred on shareholders as regards dividends by the terms of issue of the shares or by the articles, and it is pursuant to those rights that shareholders receive dividends. Those rights are attached to the shares for which consideration was provided by the original holders. Dividends are both commercially and legally a return on the investment. It would be startling to categorize dividends as gifts made by a company to its shareholders, and there is no reason to think that Parliament intended the word gift to carry anything other than its its normal meaning. So that's the disposition of the gift issue. Now, pausing there, my lords, my lady, that passage, para 41, we would submit as authority for the proposition that the reason why a dividend, at least a lawful dividend under Part 23 of the Companies Act, the reason why a lawful dividend is not a gift is that the company did receive something in return for it, namely the shareholders' original investment. That is why it is now established that the gift limb of Section 4231A and 2384A, that limb does not apply to dividends, lawful dividends. But if one then looks at paragraph 42, where Lord Justice David Richards turns to issue 2, the transaction for no consideration issue, that's where the analysis begins, and the conclusion, if I can take the court to that, is at paragraph 50 at page 419. Can I invite the court, please, to glance at paragraph 50, and then I'll make a submission about it, if I may. Now that passage we would submit as significant because the point it is making is not merely a factual one about what typically happens in practice when a dividend is paid. It's making a point of principle, namely that if the terms of a dividend do not provide for the company to receive anything in return for it, then that of itself means that a dividend falls within the second limb of Section 4231A. That is to say, the transaction for no consideration limb. There are within paragraph 52 sentences which perhaps demonstrate that most clearly. The first is just below letter E, the first sentence of paragraph 50, where Lord Justice David Richards identifies the question that he's seeking to answer in this passage, and he says, once it is accepted that the payment of a dividend involves the payment of funds beneficially owned by a company to its shareholders, the question under 4231 remains whether the terms on which the dividend is declared or paid provide for the company to receive no consideration. In my judgment, cannot be said, etc. And then again, in the penultimate sentence of this passage, the learned Lord Justice makes a point about the drafting of 423. So this is just below letter G. He says it might be said that to come within the second limb of 4231A, the terms must expressly provide for no consideration, but in my view that would be too literal a reading of the provision. Parliament can hardly have intended the operation of the section to depend on the vagaries of drafting styles. In other words, as we read paragraph 50, Lord Justice David Richards equated the absence of a term providing that there will be consideration to the presence of a term providing that there will not be consideration. In other words, if you have a transaction, whatever that might be, in Sequana's case it was dividend, but it could be anything, you have to ask what are the terms of that transaction. That doesn't need to be express. Indeed, it doesn't even need to be in writing. But every transaction will have terms. Once you've worked out what the terms are, you have to ask, is whatever is alleged by the defendant to be a benefit, is that a benefit which the terms provided that the debtor would receive? And if the answer to that question is no, then the inquiry ends there, because the benefit does not constitute consideration within the meaning of 238. And I'll come on to what the rationale for this might be, because one question that this analysis does raise, but doesn't in this passage answer, is what is the legislative purpose behind requiring terms as distinct simply from a factual inquiry as to what the benefit was? The rationale we submit is this. It is to ensure that insolvent companies which deplete their assets cannot reduce the quantum or defeat clawback claims by relying on collateral benefits that they happened to receive, but which they had no legal right to receive. For example, my lords, my ladies, suppose that an insolvent company waives a debt of £1 million that's owed to it by a related party, say a former director or employee. That's a transaction at an undervalue, because the Supreme Court tells us in Invest Bank that waiving a debt is within section 238 or 423. Now, if the related party, because they are quite pleased that this 1 million debt has been removed, if they're quite pleased about this and they choose to confer some benefit on the company, so let's say they send a bottle of wine for Christmas or they make a voluntary payment of £10,000, it would, in our respectful submission, be surprising if that could be used to reduce the quantum of the clawback claim, which is brought against the insolvent company on the basis that if you're insolvent, you shouldn't be waiving a debt of 1 million. But in that example, which I recognize is a simplistic and perhaps unrealistic one, but just to test the argument, the quantum of the undervalue is 1 million. It's not 1 million minus the value of the bottle of wine or the voluntary payment that the related party has chosen to make. But if one asks what is the analytical reason behind that intuition, it is, we would submit, the point made by Lord Justice David Richards, namely that the transaction, that is to say the waiver of the debt, did not provide that you must make a payment of £10,000 to me. If it did, then I would accept that the amount of the undervalue would not be 1 million, it would be 1 million minus 10,000. But that, I can't point the court to any authority that says this is the rationale. That's a submission we make. But we say that explains why Lord Justice David Richards said what he did in the Sequana case. It's to ensure that collateral benefits can't be used to reduce the quantum of undervalued claims. Now, before we leave Sequana and go to Brew and Dolphin, it was actually this construction of the words on terms that provide for, which enabled the Court of Appeal in Sequana to reach what would otherwise have been two inconsistent conclusions. Because one conclusion, as the court has seen, is that a dividend is not a gift. And the reason why the Court of Appeal said a dividend is not a gift is that the company does, as a matter of fact, receive something in return for the dividend, namely the original investment. But once one says that, one has to identify some reason why that very thing cannot also carry through to the second level, that is to say the transaction for no consideration level. And that other reason can't be factual, because ex hypothesi the company has got something in return for the dividend, or did get something in return for the dividend, which for some other reason doesn't count. And that some other reason is that terms of the dividend do not provide that.
Is there potentially a timing point there?
Yes.
When you're dealing with gift, Lord Justice David Richards takes into account something that has happened in the past.
Yeah.
Whereas when you're dealing with entering into a transaction on terms that provide for, you're looking to the future.
Yes, my lord, that is a potential distinction, but it seems to me that the answer to it is that it is conceptually possible for consideration to precede the thing for which it is consideration. For instance, the example that occurred to me was, suppose I lend £10,000 to somebody at 5% interest. I would get the interest after I've given the loan. So if I get £500, say 6 months after I made the loan, the £500 would not be analysed as a gift. Instead, the analysis would be that it's a return on my original investment, the loan. But that's an example of a case in which the borrower got something in return for the £500, but before they paid the £500 to me.
Well, is that the same? Because the stage at which you get the £500, you discharge a liability.
Yes. But the liability arose because of a contract under which I agreed to give them the loan. So in other words, my lord, I with respect, disagree with your lordship. Normally, consideration will not precede the thing for which it is consideration. I accept that that is true as a matter of empirical fact, as it were, but it's a factual rather than a conceptual point. It's not conceptually impossible for somebody to write a contract in such a way that the consideration flows before whatever is promised in return for it is received. It's just a matter of how the contract is drafted. So the timing point in my submission could not explain why the consideration received by the company for a dividend doesn't carry through to the second limb, the no transaction limb. And if one actually looks at paragraph 50, as I read just above letter G, the learned Lord Justice isn't making a timing point, rather he's saying that terms do not provide for the company to receive any consideration. So that's what we say about Sequana. But I need to deal with Bruin Dolphin, which, as I submitted earlier, we say actually supports us. It's that Authorities Volume 1, Tab 4, page 44. If I can invite the court, please, to go to page 51 in the speech of Lord Scott, which we've looked at. Picking it up just below letter G towards the bottom of the page, Lord Scott says the subsection does not stipulate by what person or persons the consideration is to be provided. It simply directs attention to the consideration for which the company has entered into the transaction. The identification of this consideration is, in my opinion, a question of fact. It may also involve an issue of law, for example, as to the construction of some document. But if a company agrees to sell an asset to A on terms, we would emphasize those words, on terms that B agrees to enter into some collateral agreement with the company, the consideration for the asset will, in my opinion, be the combination of the consideration, if any, expressed in the agreement with A and the value of the agreement with B.
Did the sale and purchase agreement in that case provide for the lease to be entered into?
It appears to have done so as a matter of implication or construction, because Lord Scott refers to a memorandum prepared in September 1989 at paragraph 21. He quotes from it, it's at page 52. And the memorandum says the basic concept is that Bruin Dolphin purchases the trade of AJB for a consideration of 1.25 million payable over 4 years. So that identifies that the consideration is the 1.25 million. And it then explains what the detailed scheme is, from which one could conclude that as a matter of construction, I would accept not expressly, but as a matter of construction or implication, it was a term of the first contract that the parent would make those payments. And just to be clear, I mean, we certainly don't want to overstate our case. I'm not saying that in every case you have to have an express term that says, for this transaction, this is the consideration. I'm not saying that. You could even have cases where there's no writing at all, which come within 238 or 438. My submission is a narrower one, which is every transaction will have certain terms, as every contract has terms. And one of those terms, expressly or as a matter of construction or implication, must provide for the debtor, the insolvent company, to receive the thing that is alleged to be the benefit. Otherwise, you'd have the oddity, which is what I would suggest it is in my bottle of wine example, where anything that the company happens to receive is taken into account to reduce the extent of the undervalue, even though the company had no legal right to ask for it. And that we would submit is inconsistent with the statutory purpose.
Do you go further and say a dividend per se couldn't have such terms?
No, my lady, I don't say it couldn't. I do say it usually wouldn't.
So, for example, if in this case, when choosing to declare the dividend, there was discussion as to the write-off of the, I know that I'm sure this didn't happen,
Yeah.
discussion about write-off of the pension liability, might that be a case where you could view there as being terms? I mean, the problem is terms sounds like contractual terms,
Yeah.
and in the context of a dividend, that's quite hard
No,
to apply.
no. But the way I would submit, one could test it is by asking, did the insolvent company or the debtor have a right to ask for that which is alleged to be the benefit? In other words, in this case, in the example that your ladyship is putting to me, if whatever arrangements had been made had given UKCS 8 the right to say that before I declare the dividend or immediately after, the pension liability should be discharged, that might be different. But it's never been suggested that there's anything like that. Indeed, I'm going to take the court to the actual document, which I don't think they've looked at, by which the dividend was declared, and it makes no reference to the pension.
Well, it would never do that. I mean, a declaration of a dividend is a mechanical exercise under company law, but one can envisage a shareholders' agreement that says in year one there will be a dividend to A, B, and C of X, and in year two so and so, and the agreement are by the other participants to procure that happens,
Yeah.
and there may be other terms that provide for payment the other way.
Yeah.
So it's perfectly possible you
No.
can have an arrangement where you would be showing some consideration for a dividend in an agreement.
Yeah.
Might be fairly unusual, but not unheard of. But what I don't understand is really my lady's point, which is why is it not here the case that this was part of the global transaction that the judge found in favour of, and may not have been written down, but it was definitely part of what was intended to happen in order to achieve the debt-free, cash-free, whatever it's called, transaction. So the idea was that there would be this release as part of that, the pension liabilities would be forgiven, and off we go. I mean, that is the term of the wider transaction, if you're wrong on point one.
Yes. No, I see what your lordship's putting to me. It seems to me it raises two distinct points. On the first, we respectfully agree with your lordship's observation that this is not a conceptual point about a dividend can never have terms, and your lordship
It can.
That's why I said in response to my lady's question that I don't say it's impossible, I just say it's unusual in practice. But your lordship's second point, it's the point I was going to turn to, concerns the application of the terms requirement to the facts of this case. And that will vary according to whether we win on ground one or we lose on ground one. So I'll take the two possibilities in turn to answer your lordship's question. So let's assume that...
Just before
Yes,
you do,
of
since you're moving on to the sort of application of the principles. So far we've been in 234, which is what is a transaction at an undervalue.
Yeah.
And here we know that that was found. So then you go to 2383, do you?
Yes, then one goes to 233.
So that says the court shall make an order as it thinks fit for restoring the position. Now, in deciding how you restore the position, you apply the same principles?
Yes, my lord, we would submit that one should. I see what your lordship has in mind, which is, might it be said that under 3 the inquiry is broader because it's just a counterfactual question, what would in fact. But two responses to that. First, 3 says the court shall make such order as it thinks fit for restoring the position to what it would have been if the company had not entered into that transaction, which then brings with it,
Brings you back to the
brings you back
transaction
to the transaction. And the second is a wider...
and raises issues of causation,
Yes,
which may be quite complex.
indeed. And
Because what would have happened if you hadn't entered into the global transaction?
yes.
Who knows?
No, indeed, my lord. And the other point is a more general one, which is the purpose of Section 238 is to restore the assets of the insolvent company to protect creditors. And if the company received a benefit that is collateral in the sense in which I've described it, then it would be contrary to the purpose of the provision to allow the company to benefit from that by reducing the remedy that is granted. And that's not tied to statute.
Yeah, no, I do see your point. I mean, in other areas of the law, we get the concept of whatever it is, res
Yes,
inter alia acta.
yes.
And so you say, well, that's distinct. I just wonder whether there might be a halfway house where it isn't so collateral as that, but nevertheless, in the real world, it is a benefit that has come to the company as a result of the impugned transaction.
Yes.
And there's a sufficient connection for the purposes of 2383.
Yes.
And you say not.
That's our primary case is not. Our alternative case is, if that were relevant, it would only be relevant at the stage of remedy, not in identifying the extent of the undervalue. But what the learned judge does in this case, and I'll take the court to the judgment, is the learned judge says the discharge of the pension debt constitutes consideration, which then reduces the extent of the undervalue. And that we would respectfully submit is wrong in principle.
Does the extent of the undervalue matter, except in the context of 238 subsection 3?
Probably not. Probably not. I only say probably because there may be some other procedural context in which it's relevant to work out what the extent, some set-off point or something of that sort. But it's remedy to which it would be principally relevant, I can put it like that. But Your Lordship has my submission that the broader point I make about pari passu, which is not tied to statutory language, is equally relevant to the remedial state. Indeed, we haven't got this in the bundles, but we can dig it out if it would assist, is the current state of first instance authority appears to be that you can't even run a change of position defense under section 238 or 339 by contrast to the position under 423. And the reason for that goes back to an observation my Lord the Master of the Rolls made earlier today, which is, why do we even have 238? It's because the Parliament intended there to be a clawback regime for companies which go insolvent or for individuals who become bankrupt, where it should be possible to claw back prejudicial distributions without having to prove that those distributions were made for some particular purpose. What Mr. Justice Trower says, I think it's a case called refouls, is that it would be contrary to that purpose to allow a change of position defense to be taken into account, save in exceptional circumstances. And we say that's a pointer to the point I'm making, which is, if a benefit is collateral in the sense that the company happened to get it, but had no right to ask for it, then even if I'm wrong about my linguistic point and about sequana, it's not the sort of thing which would engage the court's remedial discretion in the defendant's favor. But coming back to my Lord's question about the application of the principle to the facts, so the first possibility, if we win on ground one, then the question would be whether the terms of the dividend provided for UKCS8 to receive anything in return, and in particular, discharge of pension liability. The learned judge did not so find. My learned friends did not and do not contend that the terms of the dividend provided, the terms in the document provided for that to be discharged. And we actually have the document in the second supplemental bundle, if that has made its way to the court. Tab 1, page 2. So if the court has that, this is a written resolution dated the 24th of December 2020 by Rockrose in its capacity.
Which page?
I'm sorry, my lord, it's page 2 behind
Page
tab
2.
Yes.
Mm-hmm.
It's a document, if your lordship has it, titled Written Consent of Sole Member of Rockrose UKCS8 LLC. Picking it up in the second recital, whereas on or about December 23, 2020, the company had a loan balance owing from its sole member, Rockrose Energy, in the sum of 84 million. The member deems it desirable and in the best interest of the company to reclassify the loan as a distribution of cash to the member in an amount equal to the loan, thereby extinguishing the loan as a receivable. And if one looks at the rest of the document, it doesn't anywhere say that UKCS8 is to get anything in return. I mean, as my lord put it, that's how dividends usually are drafted. They say we are now declaring a dividend in X amount, and that's usually the end of that. But even if, in response to the question my lady put to me, even if it's legitimate to travel beyond...
Sorry, just
yes.
completing, that is framed as a written consent of the sole member, but we should presumably regard that as the relevant corporate
Yes.
document of the company.
Yes, that's right.
Very interesting that they keep on saying, resolved, that it's in the best interest of the company,
Indeed.
if they didn't have any of this in mind. Anyway.
The only other point I wanted to make about the document is to pick up on the point my lady put to me, which is if it's legitimate to look beyond the document and to ask, was it a term of the wider arrangements made at the time that the pension debt would be discharged? For one thing, UKCS8 isn't party to the SPA, and nobody has ever pointed to any decision, communication that says that the discharge of the pension liability is a quid pro quo for the dividend. So we do say that if our interpretation of Section 238, Sequana and Bruin-Dolphin is correct, and if we win on ground 1, then ground 3 should succeed without having to get involved in the factual debate between the parties. In fact, if round 1 succeeds, there's an even simpler reason why we submit that ground 3 should succeed, which doesn't require me to be right about this on terms of point. I mean, the court has my submission about what those words mean, on terms that provide for, but let's assume for a moment that I'm wrong about that, and that there isn't a requirement under Section 238 that the benefit must have been provided pursuant to a term of the transaction. Even then, there is at a minimum, we submit, a requirement that the benefit was received in return for entering into the transaction as a matter of fact, or as a quid pro quo for the transaction. That's the nexus that you need for the benefit to be taken into account.
Yes, I mean, I would suggest that's much closer to the Bruin-Dolphin facts,
Yes, because there wasn't an express term.
at least as I understand it at the moment.
Subject to the
It's
point.
the commercial deal of the overall understanding.
Yes. It's actually Bruin-Dolphin I was going to go to try to make this point good. If we can just, sorry to jump back and forth, but if we can go back, please, to Authorities Volume 1, Tab 4. Page 50. Page 50. There is a passage which the court looked at earlier from the judgment of Lord Justice Morritt.
Yeah.
And at letters C to G on this page, there is a quotation. Picking it up just above letter G, Lord Justice Morritt says, the second limit appears to me to flow from the comparison the statute requires the court to make. In each case, it is necessary to ascertain the consideration to be received by the company. In the case of Section 2384A, the transaction is either a gift or on terms that provide for the company to receive no consideration. In other cases, as provided for in subsection 4B, the task is to ascertain the value of the consideration provided by the other person, quote unquote, for the consideration provided by the company, whether or not the word consideration in these contexts is confined to its legal meaning. It clearly connotes the quid pro quo for that which it is alleged the company disposed of at an undervalue. So at least as a matter of fact, and this may not be dissimilar to the point my Lord Justice Newey was putting to me earlier, which is in other areas of the law, there are factual tests of this kind designed to establish a particular type of nexus. Now, although the House of Lords disagreed with some aspects of the Court of Appeal's reasoning, it did not, as we read Lord Scott's speech, disagree with this particular aspect of the reasoning. In fact, the House of Lords endorsed it. Paragraph 20 at page 51 near letter F, Lord Scott says, the Court of Appeal based its decision on the form of the agreements into which the parties had entered. In my respectful opinion, neither approach was right. So pausing there, the criticism of the Court of Appeal's reasoning was that it had treated the form of the agreements as determinative. But the House of Lords did not disagree with the statement of principle that a benefit must constitute a quid pro quo for it to be taken into account. Indeed, below letter G, Lord Scott said it simply directs attention to the considerations for which the company has entered into the transaction. The words for which are suggestive of the same nexus requirement. So if ground 1 succeeds, then the transaction is the dividend alone. And the question would become whether UKCS8 received any benefit in return for or as a quid pro quo for declaring the dividend. And the answer, even on my learned on the logic of my learned friend's case, is that it did not. Because it has never been suggested that the discharge of the pension liability was a quid pro quo for the dividend alone. The case advanced below successfully by the respondents was that the discharge of the pension liability and the payment of the dividend were both steps taken to achieve a cash-free and debt-free sale of UKCS8, which is why they said it should be brought into account. But the case cannot be put that way if ground 1 succeeds. Can I then turn to the other possibility? If we lose on ground 1 and the transaction is a wider arrangement, even then, well, then the question is, did that wider arrangement on my primary case contain any terms which provided for the pension liability to be discharged? Now, the first point to make is, if we lose on ground 1, that doesn't make the on terms of point go away, as it were. It would just reframe the question. The question would become, did the wider transaction contain terms which required the pension liability to be discharged as part of that transaction? Not only did it not contain such a term, it actually contained a term to opposite effect. And perhaps I can show the court that. It's in the share purchase agreement, which is in the core bundle, tab 11D. So this is the SPA between Rockrose and FIOGC. At the top of page 315, if I could request you that, please, page 315, one can see that the parties are defined as Rockrose as the seller and the government of Fujairah via FIOGC as the buyer. So those are the only parties to this contract. About halfway down page 315 is a defined term, company. That's a reference to UKCS8. And then at page 316, at the bottom of the page, clause 3.4 says this, page 316. On completion, the seller and buyer agree that the company and its subsidiaries shall waive the right to receive any amounts, whether provided through loans, subscriptions, intra-group payments, or otherwise, due to them from the seller's group. So clause 3.4 is what one might call, and what I think we did call in argument below, as a one-way waiver. It provides that upon completion, UKCS8 and its subsidiaries will waive any debts owed to them by the Rockrose Group. But it does not provide for any waiver the other way. That is to say, for the waiver of any debts owed to the Rockrose Group by UKCS8. And that, in our respectful submission, is significant because it shows that the terms of what the learned judge found to be the wider arrangement, namely the sale of UKCS8, did provide for the discharge of the 84 million, hence the dividend, but not for the discharge discharge of any debt in the opposite direction, including the pension debt of 39 million pounds. Can I, before I conclude on the legal point, deal with the reasons the learned judge gave for rejecting our submissions? So it's at paragraph 234 at Go Bundle tab 7, page 180. Actually, 233 is where it starts. At paragraph 233 at page 187, the learned judge refers to Bruin Dolphin, which the court has looked at. In the first sentence, the learned judge says, consideration can be found in benefits received by the company as part of a wider arrangement, even if there's no express provision to that effect. We don't disagree with that. You don't need an express provision, but the court has my submission that you do need a term, even if it's not expressed. And then at paragraph 234, perhaps I can ask the court, please, to look at 234 and 235, which contain the remainder of the learned judge's reasoning on this point.
Yeah.
So we make two submissions about those passages. First, as to para 234, the premise of that passage appears to be that the transaction is not the dividend, but the wider arrangement. A premise that is perhaps most clearly articulated in the final sentence, where the learned judge says that Sequana does not purport to say anything about the appropriate analysis, where the relevant transaction is a much wider arrangement, unsurprisingly, since that was not a question which was before the court. But if ground 1 succeeds, that premise will fall away. And there is, as we read para 234, no finding by the learned judge that the discharge of the pension debt can be taken into account even on that hypothesis. In other words, on the hypothesis that the transaction is just the dividend. In fact, the penultimate sentence of 234 rather suggests the opposite. That is the sentence starting with all that Sequana decided was, because the learned judge appears there to be recognizing, in our submission correctly, that the ratio of Sequana is that where a dividend is the transaction under 423, then that is a transaction on terms which do not provide for the company to receive consideration. So that's what we say about para 234. If we fail on ground 1, then the relevant reasoning in the judgment on this point is at para 235, where the learned judge deals with the one-way waiver point that I've just made and rejects it. And she says in the first sentence, this disposes of the claimant's argument that the only consideration which it is permissible to take into account is that which was provided for in the SPA itself, and that since the SPA contained a one-way waiver of sums, the discharge of the pension liability cannot in any event be taken into account. Now, the word "this" in the first sentence of 235 is probably a reference back to 234, and in that passage, the learned judge was making the point that Sequana is not relevant if the transaction is a wider arrangement and not a dividend. But with respect to the learned judge, Sequana, we submit, is relevant even on that hypothesis, because at paragraph 50, which the court has seen, Lord Justice David Richards is making a point about what the legislation means, what the words on terms that provide for mean, and a proposition about what the words of section 238 mean could not be confined to cases about dividends, because the meaning of the statute can't change according to the facts of individual cases. So we do say that sequana is relevant even if the transaction is not just the dividend but wider arrangement. For those reasons, my lords, my lady, we say that ground 3 should succeed irrespective of the outcome of ground 1 and irrespective of the factual debate between the parties. Indeed, the factual points won't arise if this part of our case is correct.
Because there's no term providing for it to be a quid pro quo.
Indeed, precisely. Yeah. If we are wrong about the legal point, then the factual issue will arise. But at this stage, I should pause because we've reflected on the indication the court gave this morning. I mean, the position, my lords, my ladies, at the moment we have permission to appeal on the factual points as well. There is an extant application to rely on new evidence, a further application by the respondents served on Friday to rely on responsive evidence. I entirely appreciate that those raise complex factual questions, which will require detailed analysis. If I understood the court's indication correctly, it was that, well, obviously if we lose on grounds 1 and 2, then ground 3 won't arise because our claim will have failed. If we win on grounds 1 and 2, I understood the court to be envisaging the possibility that the case would then be remitted to the commercial court to deal with questions of remedy, as part of which the pension issue could be investigated.
Well, we'd have to hear submissions on what should happen in that event. What would you say?
Well, I'm ready to make submissions on the substance of the factual points. I come prepared to do that. But if the court is minded not to...
But the judge didn't decide on remedy.
The judge didn't decide on remedy, my lord, that's right. But the judge made factual findings adverse to our case about whether the discharge of the pension debt benefited UKCS 8. And we say those factual findings are wrong.
No, I understand, but I mean, we'd have to go into all the detail and hear evidence going beyond, particularly if we had admitted your new evidence application.
Yes.
I mean, I think we should hear submissions from you on why we should do all that.
Yes.
And then hear from Mr. Nash on all the other points and on why we should or shouldn't do all that and what we should do if we were against him on grounds 1 and 2. And indeed the legal point on ground 3 that you've made so clear this afternoon. But, I mean, this is sort of not the furthest reaches of the case, but it is a little way down the line. And I can see that we're going to get into an awful lot of detail and then discover that it's that one side or the other is submitting that we actually haven't got the material to decide it. And that there hasn't been cross-examination on the new documents. They may be very significant if they're relevant. I mean, that's if we get all the way down to 3, you lose the legal point on 3, but the factual point on 3 remains open.
Yes.
And so on. So, I mean, it doesn't sound like it's very good use of our time to hear what I suspect will be a day's argument on a point that may never become relevant, and if it does, it's likely to be resolved by being sent somewhere else.
No, I entirely see that, my lord. Can I make 2 initial submissions, as it were?
Yeah.
The first is that if the court were minded to take that view, and I entirely see why it would not be particularly useful deployment of resources to hear a point of that sort, especially in this court. The only concern on our side of the court is if it were to be remitted back, we would not want it to be suggested that there's some estoppel or we are bound by the adverse factual findings the learned judge has already made, which we have permission to appeal, and we have appealed in our skeleton.
No, I mean, I think it's perfectly clear that if you've got that far and we're talking about remedy, the factual findings that she's made as to why you were not liable, why they were not liable, can't stand against you. I mean, again, we'll hear Mr. Nash on that, but I mean, particularly when at face value it appears there was material which ought to have been disclosed that wasn't. I mean, I'm not saying it's anybody's fault.
No.
It's just happened. But it seems to me, since she wasn't dealing with remedy, I mean, I'm speaking only for myself, and I'm just speaking off the cuff at this point, but it seems most likely to me that the court would ultimately conclude that this was a bridge too far for this court, that it was risky and undesirable for us to make all the causation decisions that need to be made. I mean, Section 241 is quite complicated.
It is.
And there's other authorities which she no doubt didn't hear about on Section 241. And I think, speaking for myself, I just think it's most likely that we would decide that it should go back for somebody else to resolve all that on terms, so both of you would have to make submissions about whether any of the findings should be saved and in what way. But obviously our judgment on grounds 1 and 2 will say something about the findings,
Yes. of
whichever
course.
way we decide. Well, I mean, if we decide, even if we decide in your favour,
Yes,
because of the points I put earlier to Mr. Allison.
indeed.
Yeah.
My lord, I'll take instructions, but for my part, that with respect, we will certainly not resist that.
Okay. Well,
Provided the court
why don't we move forward, unless my lord and my lady have anything to say? Why don't we move forward on that basis with all to think about it overnight and return to it? And if it involves you making more submissions on those points tomorrow, that's fine.
I'm very grateful.
All right.
I'm very
Okay. Well, thank you very much for that. So, Mr. Allison, do you want to sweep up, or have you finished?
I don't believe there's anything to sweep up unless there's anything further from the court.
No, we don't think so. So, Mr. Nash. Good
Thank you,
afternoon.
my lord. My lord, my lady, can I begin with a few points arising out of the exchanges we've had this morning and this afternoon? Firstly, on the last point we were touching on, which is what is the position on ground 3 and the question of remission. Perhaps the easiest way to understand the issues here is to look again at paragraph 250 of the judgment, which is at page 193 of the core bundle. And you'll see there that the findings that the learned judge made in relation to this premium was that she accepted that the entirety of the premium was rechargeable to CS8 via CS11, and it properly represents a benefit to CS8 and thus consideration received by CS8 as part of the arrangement of which the dividend formed part. So there are two aspects to that. There's firstly the legal decision that it comes into account as part of the consideration, and secondly there was a factual decision made in the face of arguments to the contrary that not the entirety of that premium was chargeable to CS8. And the complexity of that, you may have picked up from the documents, is that it said that other companies with involvement in the Bray field were responsible for some parts of that premium and would have been exposed to a recoupment. Those were the findings that the learned judge made. Now, my learned friend Mr. Hubbard is going to deal with ground 3, which is why he's sitting there, I hope without presumption, in due course. But we would say that if there is to be a remission on remedies, well, firstly, that there should be a remission on remedies because there are other matters, the causation argument, which the Master of the Rolls has referred to, but also issues as to whether what, in true commercial terms, is happening here in terms of the debt which the claimants claim to have against CS8 and whether it has in fact been recovered by them many months ago by virtue of their lifting of CS8's production from the Bray field. Those are all questions which the judge heard argument on but didn't have to decide because of the way she dealt with matters, and those are certainly matters which would have to be dealt with by way of a remission if we get to that point.
So you would presumably say it should go back to this judge?
It should go back to this judge. We have no reason why this judge, having heard evidence, should not deal with it.
But it would be shorter, wouldn't it?
And it would be shorter, certainly. Yeah. But as you've seen from paragraph 250, she did make findings on both the legal point and on the factual point, as to the rechargeability of this premium, and those are the findings which are subject to Maloney Friends' appeal. So it seems to us that unless those matters are to be dealt with on the appeal, those are findings which we would say stand, subject only to this question of the application for new documents to be put in. And if it were to go back, as it were, in toto to the judge below for a hearing on remedies, the only issue that ought to be open for debate before the learned judge is firstly the question of the admissibility of the new documents, and secondly, of course, what they show. Now, the problem, again, we anticipate is that the question of the admissibility of the new documents is of course, classically an appellate one, because we say that this material was available below and wasn't deployed, and there is simply no basis on which...
No, but if the judge didn't deal with a relevant question because of her findings which turn out to be wrong, let's assume findings or holdings that turn out to be wrong, then the fact that there is the various matters now have to be dealt with don't require a finding under Ladden Marshall that this matter, that they should have been deduced earlier because it wasn't really relevant to anything she actually decided. I mean, you can't be sort of, you can't have such a strict embargo in respect of a case where there's a trial of liability in quantum, the judge decides only liability because they decided against the claimant, and you don't deduce some evidence that would have been relevant to quantum, but when you get to the Court of Appeal and the evidence becomes relevant, you get it sent back on the basis that it's all liability, all quantum has got to be decided on the basis of the original evidence. Sounds a bit unfair to me. What do you think?
Well, I think it probably depends on what decision were to come from the Court of Appeal and the extent to which...
Yeah, well, of course. I mean, but if there is liability,
yes,
which there wasn't below,
yes,
then I would have thought the assessment of the liability ought to be large.
well, for example, on this question of transaction, ground one, if the court were to allow the appeal on that basis, we would still argue that the premium comes into account. That's a matter of argument.
No, of course you would. I mean,
So,
of course you would. Well, I mean, I say of course you would. I mean, subject to the arguments we've heard this afternoon on
yes,
on the legal question, but you would say he's wrong about that.
yes, absolutely. But if we were right in saying that, then we would be entitled to, as it were, hang on to the judge's conclusions on that point. So it does all depend on what the court's ultimate
Well, that's
decision
true,
is.
and you know that's been going through my mind. But at the moment, I think we're a long way away from seeing how this might be resolved. But I, for my part, would prefer to hear your argument on grounds 1 and 2 and the first part of 3 before we rehearse all that, because I think at that point it may be a bit more clear, at least in the court's mind, if not in yours, Mr. Nash.
Well, I'm sure together we will arrive at some consensus, I'm sure, my lord.
Because you're going to wow us in a minute with your...
Well, I'll try. So that was my first point arising out of today. My second point, my lord, the Master of the Rolls has expressed at various points during the course of the argument some surprise at the judge's findings.
Well, not surprised, but they are clear findings, aren't they?
Clear and strong in my client's favour.
Judges
yes.
are entitled to do that. I mean, that's their job.
Absolutely.
Yeah.
Well, that of course is our primary submission, my lord. But one remark that I'd like to just pick up on, there was a lot of focus in the argument about cash-free and debt-free.
Yes, there was.
And it was said, in fact, again, your phrase, that this seemed to have become a sort of magic potion.
Yes.
My lord...
Sorry about my colourful face.
Not at all. That wasn't what happened below. That's my point.
There was no magic potion below.
There was no magic potion. The learned judge did not approach this case on the basis that once it was established that this was a cash-free, debt-free sale, and that was a perfectly conventional transaction, that therefore everything, as it were, fell like dominoes in my client's favour. That would have been a facile submission on my part, and it certainly wasn't the way the judge...
I wasn't actually talking about the hearing. I was talking about the way the judgment reads.
Yes.
And the reason I put it that way is because every time you come to a critical point in the judge's reasoning, you get a reference to the cash-free, debt-free. I'm entirely electronic, so I use the search mechanism quite a lot in documents. And I found it's regularly used, unfortunately misspelt in some places, which makes it, you have to search for the misspelling as well. But it's at critical points in the judge's reasoning, this is the serious bit, she says, for every finding, she says, no, that point doesn't carry any weight because what they were doing all the while, effectively, were driven by this cash-free, debt-free transaction, which is a perfectly normal thing, as Mr. Jenkins told me.
Yes.
And I accept it's commercially entirely sensible and viable and acceptable. Now, you know, that's therefore was, to my reading of the judgment, did drive her reasoning. Whether it's a magic potion is probably not helpful to say.
Well, the first point to make about all of this, my lord, is that you'll appreciate, of course, below, all three limbs of the claim were being pursued.
Yeah.
So it was being said 238, 43, and conspiracy, unlawful means conspiracy. So, and the way it was put factually was that my clients had devised this scheme to dump CS8, to use the language I think the judge picks up on, as part of an asset stripping exercise in the expectation that once it had gone out of the Rockrose group, it would inevitably go into default and the creditors would be left in the air. So that was the factual case that was being put and was maintained through to closings. So it's unsurprising that in that context, she often refers to the point that the transaction was a legitimate one, and the cash-free, debt-free aspect of it was an entirely conventional way of going about this kind of transaction. But it doesn't mean that she held that the specific requirements of Section 2385 were fulfilled simply by virtue of the fact that it was a cash-free, debt-free sale, and that is a conventional sort of transaction.
Look, I completely accept that point. I wasn't making it as the only point in the case. I was just saying that if you read this anyway to an untutored eye, and I assume your eye will be more tutored, Mr. Nash, and you'll explain how it should be read. But the way I read it when I just read it as a judge does, hearing an appeal, it came across like that as being a significant part of her reasoning. Of course, there are other parts of the reasoning, and I think it is wise to bear in mind your important point that this was a 43 claim, a fraud claim, effectively,
Yes.
and a conspiracy claim, and therefore that's how it was run. And of course, sometimes when you put cases very high, judges go and don't like them.
And go the other way.
Yeah, go the other way. Yeah.
Exactly.
Yeah.
Well, I'm not suggesting, of course, that that aspect played no part. I'm simply trying to put it in the context of...
Was it only Mr. Jenkins?
I think the phrase came from Mr. Jenkins, but Mr. Mazzagatti gave evidence that the intention was to enter into a clean sale, a sale which did not carry over either liabilities or assets. There's a reference, I'm told, in Supplemental Bundle, tab 7, page 30, to that effect. Perhaps we'll come back to that. I don't want to be...
This was a 3-week trial, is that right?
Must have been, yes, of that order, yes. 3-week trial, yes. And of course she heard, the learned judge heard evidence from both Mr. Mazzagatti, who was the main, as it were, directing mind, and to a lesser extent Mr. Dixit Dominus, who were both cross-examined hard for in Mr. Mazzagati's case, I think, over 2 days.
So Mazzagati, paragraph 94, I agreed that we should extinguish the intracompany debt so that we could sell CS8 free of debt and cash at completion, standard practice and consistent with what CS8 SPA provided.
Yes.
If we'd not done that, there would have been a debt owing from us to CS8 immediately after completion. I must say, I'm indebted to you for the abbreviation CS8, which is so much more wieldy than UK CS8.
Yes. The names get a bit of a muddle. My Lord, this takes us, I think, to paragraph 144 of the judgment, which was particularly focused on by my learned friend this morning, where it suggested that the learned judge got into a muddle about the relationship between section 238 and section 423.
Well, I think he goes further than that and says that she was completely, totally, 100% wrong
Yes.
on this point.
Yes, you're right. I should be more precise about this. She doesn't, my lord. What she has said here, and perhaps we can go through it, as it were, or pass it line by line. She makes firstly the point that the transaction at an undervalue is identical in both sections, and I don't think that is in doubt. The identification of the purpose and intent with which the transaction was entered into for the purpose of 423 will almost always turn on the same evidence as that required in relation to the statutory defence under 2385. Well, that also, as an observation of the realities of evidence, was and is correct. That's how it was dealt with below. There was evidence before her as to the purpose and motivation, and of course good faith or otherwise, of the participants in the transaction, both for the purposes of 423 and 238. She goes on, in practical terms, therefore, the claims under the two sections are likely to stand or fall together if the defendant fails to establish a defence under 2385, it cannot succeed under 423, and that must be right, because you'll have failed to establish good faith under 238 or failed to establish reasonable grounds, and that means it's going to be very difficult to establish a 423 defence. Converse, if it does establish such a defence, and this was the point that became operative, then the claim under 423 will fail. And what happened here was, having made her findings, and specific and developed findings for the purposes of the defence under 238, she dealt very quickly with 423 because clearly you couldn't establish the nefarious intent, the intent to prejudice your creditors.
And then she acknowledges the possibility that you of a separation in
Yes.
the last part. You say that's all right.
I say that's all right, my lord. I would accept that she may have gone a little too far in saying that there'll be rare cases. She says it's theoretically possible that a claimant fails under 423, but the statutory defence still fails because there are no reasonable grounds for belief or because it lacked good faith for some other reason, but such cases are likely to be rare. Now, that may be going too far, I accept, but that isn't what happened here.
Yeah, I mean, the
basis
reason
of her
why
decision.
everybody's balking on the bench at this submission is because of their ancient familiarity with Section 172
I understand.
and the fact that it was something that was well known to insolvency lawyers before the law changed, and of course there was no Section 238, so there was preference and there was Section 172, but there was no Section 238. So I would say that what is not acknowledged in here, even if it's broadly a fair comment, I think is really all it is anyway.
Yeah.
What is not acknowledged in here is the novelty of taking fraud out of the equation.
I entirely understand that with respect, my lord. I suppose all I need to say, well, firstly, as your lordship has said, this is really very general comment here about.
Well, you say, I mean, I understand what you say about this. You say it really doesn't inform any errors she may or may not have made. If she made errors later, that's fine, she did. And if she didn't, she didn't. It doesn't tell you whether she did. And you would probably also say, I mean, I would also just comment that looking again at Cork, it's quite interesting. They make a lot of, it's quite useful to read the bit on fraudulent preference, because the error, the whole thrust of Cork was that all this concentration on fraud doesn't help anybody. And in fact, they make a very perspicacious point that if you call it fraudulent preference and you ask somebody for the money back, they won't give it to you back because you're accusing them of fraud.
Yes.
If you call it avoidable preference, they might give the money back on the basis that you're not accusing them of fraud, it was just a mistake.
Yes.
And so it's really self-defeating. And that pervades the whole report, which is that we should have insolvency claims that can be brought without labelling everybody a fraudster.
No. Well, that takes me to my next.
Just before you do, I mean, I quite follow the point that really this case turns on what happens in relation to the specific requirements. But there does seem to be an assumption here that 238 doesn't really add anything.
Yeah.
Well, that's completely contrary to how insolvency lawyers, I think, would generally see matters. Section 423 doesn't even require an insolvency. What it requires is a purpose and a transaction at an undervalue. You don't have to have insolvency at all. And Section 238 was obviously brought in to provide something in support of the pari passu principle where there was an insolvency, without having to require to prove the nefarious purpose. So the idea that they're always run together, I would think, is completely misguided. The idea that they, in principle, stand or fall together, I would have thought is misguided too. Typically, a liquidator will bring a 238 claim alone, I would have thought, and will not want to engage with 423.
Yes, well, I would accept all of that, of course, my lord, but the main point in relation to this paragraph is that what the judge is thinking about, and this reflects the way the case played out at trial, is that if we are successful in our 238 defence, then the claims based on dishonesty and impropriety, 423 and conspiracy, can't win, can't succeed.
No, I can't follow. If you win on 238, it's more or less inconceivable that you lose on 423.
Insofar as a matter of legal theory and musing in this paragraph, that the reverse might, the reverse analysis might also work. I don't suggest that that's right. 423.
She wasn't trying to reinvent the law of insolvency, and
No.
she was making a comment which, as you may say, may turn out not, as for the reasons my lord has given, may turn out not to be entirely accurate, and in fact would stick in the craw of seasoned insolvency practitioners. But so what? Actually, we have to look at the substance of what she decided, and if she got that right, she got it right, and if not, not.
That's the submission mode.
Yeah.
Now, the next point, again on remarks made during the course of today, the purpose of Section 238, and of course there's no dispute that the principal purpose, again as my Lord the Master of the Rolls has already said, is to allow restoration of the position, preservation of pari passu, without proof of fraud or dishonesty. But it also provides for a defence under Section 2385. And simply to say that the section is required to preserve the pari passu principle, and therefore any transaction which encroaches on that principle should be disallowed, does not give sufficient weight, in my submission, to the existence of the defence. There are two roles for Section 238. Firstly, without proof of impropriety or fraud, to require a justification of transactions at an undervalue at a relevant time, but secondly, to allow the directors of a company to make honest and reasonable decisions at the time, provided the conditions of Section 2385 are fulfilled. That is to say, they, in good faith, believe that their dealings, I'm going to use the word dealings as a neutral term for the moment, are for the benefit of the company. And those two limbs are both provided for and important. My Lord the Master of the Rolls commented earlier that really what this is all about is allowing directors to make decisions at moments of corporate crisis, and if those decisions turn out well, then everybody's happy and we never hear of it again. And if they turn out badly, then you end up in court. Now, with respect again, I suggest that's going a little too far, because the decision, the analysis, the assessment takes place at the time of decision. The directors are entitled to make honest and reasonable decisions for the benefit of the company at the time of insolvency, and irrespective of how they turn out, they are judged by their good faith, purpose, and reasonableness at that time.
Well, the problem with that, of course, I agree partly, but the the problem with that is the terms of 2385, the objective part of 2385, which provides, as we read again and again, which I can't now find, but
997.
It's in the authorities.
997.
and 997.
Yeah.
Yes, that there have to have been at that time reasonable grounds for believing the transaction would benefit the company.
Yes.
Now you have to have reasonable grounds for believing the transaction would benefit the company. Now, there's going to be arguments about that, depending on how risky it is. Are there not?
Yes, and for the example given that you're going to raise cash and it's going to keep you stumbling on for another week.
Yeah.
For example.
For example.
That's not good enough.
Well,
Or
may
well not be good
Depends
enough.
what's going to
let's put it
happen
that
in the week.
But the assessment is always at the time of the decision.
But I did only say, I only said that if you are insolvent and you make such a decision knowing it's risky, you're likely to end up in court. And not that you're likely necessarily to lose.
No.
It may be perfectly reasonable to have made that decision. It must depend on the extenuating circumstances. And the reason, just to fill you in, I was putting what I was to Mr. Allison, was that here it might be said unkindly to your clients that this wasn't a case of a tremendous emergency, and in fact all the motivations were malign in some way, or not dishonest, but looking to achieve a particular end result which did have the effect of taking money out of the company's estate. But those findings of fact have been made against Mr. Allison.
Yes.
And so he's got a problem. And what I was imagining you were going to be saying to us is, if you put end to end in a document all these findings of fact that the judge made, none of which is challenged, you can see how she perfectly reasonably, and we just don't interfere with judges for the sake of it, even if the transaction is what he says it is, perfectly reasonably said there were reasonable grounds for believing the transaction would benefit the company, taking all the risks into account. We have, I think, to look at it from her lens if the facts are not challenged.
Yes, well, that's certainly my submission, my Lord, and in due course I will take you to a brief remark, I think, of Lady Rose in the Privy Council appeal, where she also makes the point that it's very difficult for this court, it's an obvious point, to get a sense of the entirety of the evidence by pointing to sentences and transcripts.
Well, we haven't fortunately had the transcripts, but we've had a very eloquent judgment.
Yes, well, I'll make that point when it becomes relevant. But just finally on this point about when the assessment is made, my Lord Justice Newey referred to Bruin Dolphin and the possibility that one looks a bit beyond the actual date of the transaction. The decision in Bruin Dolphin as to the value or otherwise of the sublease does appear to have been focused on the value of the sublease covenant at the time it was entered into. If we go, please, to page 53 of the authorities.
I might say I've always found Phillips and Bruin Dolphin very difficult on this aspect.
Yes.
And there are cases that deal subsequently with it.
Yes, it's paragraph 23, page 53, and that's within tab 4 of the authorities bundle. And you'll see
So which paragraph?
paragraphs 23 and 24 on
Thank
this
you.
point, where Lord Scott sets out the submissions in relation to the value of the sublease, and he asks the question at the bottom, at the end of paragraph 23, what was the value in money or money's worth of a covenant by PCG, that was the parent company, the buyer, that was so precarious? And it was precarious because the sublease was capable of being, well, the head lease rather was capable of being terminated at any time by virtue of the covenant against creating subleases. And then paragraph 24, perhaps I could invite the court, please, just quickly to read through that again. And then paragraph 25 as well.
Yeah.
So I entirely take my Lord Justice Newey's point that it's a little bit unclear exactly what has been decided here, but my submission is that it seems that Lord Scott was saying that the covenant under the sublease was, at the time it was entered into, precarious and of no real value. But in arriving at that conclusion, it was permissible to look beyond the date of the transaction to find out what actually happened. And what actually happened was that the head lessor did disclaim or terminate the head lease. And so the apparent precarity, if you will, became a real weakness.
Well, the start of 26 refers to valuing it as at the 10th of November.
Yes, ex post facto. Yes.
Well,
Yeah,
the
no,
premise for it is valuing it
No,
at
you're helping me more than I
10th
realise.
of November.
Lady. Valuing the covenant as at the 10th of November, quite right. So,
And actually, if you read on, you'll get where the events, or some of them on which the uncertainties depend, have actually happened. It seems to be unsatisfactory and unnecessary for the court to wear blinkers and pretend that it does not know what has happened. And I think in a different case years ago, I had deployed against me the Bulfer principle, which is you take into account what has actually happened.
yes.
And at the time when someone referred to the Bulfer principle, I thought, how on earth do you spell that? And the answer is BWLLFA.
Right. Well, we may look at that overnight just to see there isn't some point that arises out of that one as well. But in any event, my submission, of course, is that the assessment for the purpose of 2385 has to be done by reference to the situation as it appeared and the decisions as they were made at the time. So, my lord, my lady, those were some comments on some points arising during the course of this morning. Turning then to the appeals and ground one transaction. Of course, I'll go as necessary to the judgment and the specific grounds of appeal, but can I begin with some more general comments? The appellants focus on the single word in isolation, transaction, under ground one, and contend that the judge misidentified the transaction at issue in these proceedings. That, we submit, is a somewhat oblique and distorting way of approaching both Section 238 and the issues on this appeal. It's clear from the statute itself and on the authorities that transaction has been given a deliberately expansive meaning to encompass dealings, using the neutral term, other than the simple case of a bilateral contract. And it wasn't disputed, either, of course, before the judge or here, that the declaration of a dividend is capable of being a transaction for the purposes of the section. But given this expansive meaning, it's unhelpful, and we suggest a mistake, to focus solely on the word transaction in isolation as a means of defining the circumstances in which Section 238 is engaged. The relevant term is transaction at an undervalue, and what that means is set out in Section 238(4). So the requirements at the first stage of any inquiry under this section is to decide three things, apart of course from relevant time, which is an issue here: whether the company has, 1, entered into, 2, a transaction, 3, at an undervalue, and if so, what is the extent of the undervalue. And those three elements interact with each other in the assessment which the court makes of whether Section 238 is engaged. And that is how the judge approached matters in this case. If we look, please, at the judgment at paragraph 139A on page 148 of the core bundle, she begins by saying there are two basic threshold requirements for a claim under the section.
Sorry, I didn't get the
I'm sorry. 139A
Thank
on
you.
page 148.
Yeah.
Two basic threshold requirements. There must have been a transaction at an undervalue, defined in 2384 as a transaction on terms which provide for no consideration, etc. And B, the transaction must have been entered into at a relevant time as defined in section 240. So she correctly said that the threshold requirement was not or not addressed by focusing simply first on transaction, but on the concept of a transaction and an undervalue. And that's the right approach, because indeed, as the appellants emphasise, the purpose of 238 is to reverse dealings which have extracted value from the insolvent estate, save, as I've said, where such dealings are defensible under subsection 5. So the first question is whether there has been a dealing or dealings which has extracted value. Now, I will come to the cases in due course, but I'll say now that they bear this out. The error identified by the House of Lords in the Court of Appeal's decision in Brewing Dolphin was to have focused too much on the form of the transaction and not enough on the question of whether there had been a transaction at an undervalue, that is to say, on what the consideration was for the share sale agreement. The focus was entirely on whether the share sale agreement was distinct from the sublease of the equipment, so as to exclude consideration of the value of the sublease. Similarly, in Feakins, there had been dealings which had diminished Mr. Feakin's assets to the prejudice of his creditor, who was the intervention board. Mr. Feakins himself wasn't a party to the critical steps, which was the sale by the mortgagee bank of the land subject to an agricultural lease and the subsequent release of the lease by the company who held it. The decision was that the agreement between Mr. Feakins and H, who was his future wife, that they would collude to bring about this diminution in Mr. Feakins' estate, brought about by the sale of the land subject to a lease, followed by the implementation of that collusive scheme, together form the transaction. And that's an example of where, in determining where the perimeter of transaction lies for the purpose of section 238, or indeed 423 in that case, the court is concerned to identify whether, in commercial reality, there has been an extraction of value from the insolvent estate, and if so, by how much?
And just to be clear, are you going to come back to Feakins and Lord Justice Miles' explanation of it?
Yes. So, my Lord, it's a fact-sensitive question whether there's been a transaction at an undervalue and what the undervalue is, and there's no conceptual bar to having regard to dealings to which the company is not a party, as being part of the transaction at an undervalue. That's the Feakins case, or indeed including consideration received by the insolvent company under a distinct contract to the agreement which is said to have caused the alienation, that's Bruin Dolphin, in calculating the undervalue and in, as it were, drawing the perimeter around what I'm just going to call the TUV, just to, rather than transactions and undervalue, the TUV. Now, before the judge, it wasn't disputed that whether the transaction was identified as comprising the dividend alone, or the sale transaction between Rotrose and Fujairah with all its constituent elements, it wasn't disputed that there was a TUV for the purposes of section 2384 of the Insolvency Act. And that's because when you consider all the constituent elements of the sale transaction, there was still a shortfall between the dividend at $84 million US dollars and 100% value of the premium liability at $53.7 million. So as to whether it was permissible and indeed necessary to consider the transaction, however it was defined, in its business context at the time it took place, the claimants, the appellants, took a somewhat ambiguous position. They certainly submitted that if the transaction was the dividend alone, then the question of whether the dividend alone was entered in good faith and for a proper purpose had to be considered within that very confined assessment. But they said in relation to the 423 claim, and indeed the conspiracy claim, that the wider context, the purpose, the supposed asset stripping and dumping exercise, was relevant for the basis of whether the transaction had an improper purpose for those two claims. That's a point that's recorded by the judgment. We don't need to look it up, but it's recorded at paragraph 252 of the judgment on page 194. Now, we say there's no reason why the purpose of a transaction should be assessed in different ways for the claim under 238 as it is for the claim under 423. If you can find your nefarious purpose from the context under 423, you can find your good faith purpose under 238, again by the context. But be that as it may, our submission was and is that however the transactions identified, the defence necessarily involved an assessment of the purpose and benefit of the sale transaction for CS8, either because the sale transaction was the capital T transaction, or because it's not possible to assess the purpose and benefit of the dividend without considering the purpose and benefit to CS8 of the sale transaction of which it formed a constituent part. And that is what the judge did with her conclusions as to purpose at the judgment, paragraphs 262 to 263, page 200 of the bundle. And can I just remind you of what she says there? Look it up at page 200. Defendants argue sales of Fujairah entered into in good faith for the purpose of enabling CS8 to carry on its business, either pursuant to an agreed common strategy with TAQA or following an on-sale to TAQA. They submit the impasse between Rotrose and TAQA could not have been resolved simply by allowing things to continue as they were and using the Zayed loan to put up security. By contrast, the sale to Fujairah was expected to create an environment in which it was entirely likely the parties could agree a common strategy for the Bray assets or achieve the sale of the company. In my view, this was at the main purpose, or at the very least a purpose, of entering into the overall arrangement. That, of course, is a conclusion of her findings which she had been dealing with up to that point. So, my lord, my lady, in this court, the appellants put the correct identification of the transaction at the forefront of their submissions. And we ask why. Well, we suggest there's some obvious answers. Firstly, because they need to identify some error of law on the part of the judge to get off the ground, as it were. And secondly, they do this because they consider that if they can persuade this court that the judge erred on this, then her conclusions about purpose and benefit can be disregarded, and the decision on whether the defence can be made out is at large in this court. And that seems to be the point that is made at paragraph 47 of the appellant's skeleton argument in the core bundle tab 2 at page 30. And again, I'd invite the court just to look at that again, just to remind yourself how it's put. If ground 1 succeeds, it follows the analysis of 2385 is unsustainable because she would, on that hypothesis, have approached it on the correct premise that transaction is the sale rather than the dividend. That issue would then fall to be decided afresh, and the claimants submit there can only be one answer, not least because the unnecessary removal of 84 million cannot reasonably have been thought to benefit the company, etc. Now, the way that's expressed is a way which suggests that the question of whether or not to allow the defence is a discretionary one, and what they have to show is a vitiating error by the judge, and then, as it were, it's all up for grabs on appeal. That's not right. The defence under 2385 is not a discretionary decision. It requires findings of primary fact as to the intention of the parties to the transaction, which here in effect means the intentions of Mr. Mazzagatti, and findings about the benefit or otherwise of the transaction, together with an evaluative judgment as to whether on those facts the defence is made out. We say, of course, that the judge was correct in her identification of the transaction, and it flies in the face of commercial common sense to regard the declaration of the dividend intended to obtain a release of some intercompany indebtedness so that an entirely conventional cash and debt-free sale could be effected. It would be absurd to regard that in isolation from the sales transaction. But even if we're wrong about that, her conclusions and purpose and benefit are not vitiated by the supposed modification of the transaction. She made findings about those matters with the benefit, of course, of having seen Mr. Mazzagatti be cross-examined, and she concluded, she made findings about the purpose and benefit to CS8 of that transaction, having regard to its place as a step in the sale, and she was entitled to reach those conclusions and make those findings.
I mean, you're obviously going to come to this in the context of ground 2, but if you take, say, paragraph 263, the judge says, well, this was the main purpose of entering into the overall transaction arrangement. So she isn't actually addressing herself to the dividend on its own.
Yes, I'll come on to that, my lord. I think I'm going to make some points about that under ground 2 specifically.
Yeah.
Now, the appellant's submission is that irrespective of the operation of the defence, the identification of the transaction must be confined to the dividend because, I'm now quoting from the skeleton, the statutory language is apt and was designed to catch every disposition of property by an insolvent company for which it receives nothing in return. My lords, my lady, that's conclusory reasoning. It's precisely in order to identify whether a transaction has taken place at an undervalue that the court must decide which dealings comprise the transaction and what consideration has been paid in return for whatever has been paid out. There's no compulsion in the language of the section or its purpose which requires the court to identify a single dealing in isolation from other connected dealings as a transaction, and indeed a TUV to boot. If looked at in a common sense way, it's clear that value has not in fact been extracted from the insolvent estate. The appellants say it's in the nature of a dividend that it and it alone is a transaction, and they say that conclusion is compelled by sequana. Well, it isn't. I'll explain when we get to that case. And that any other interpretation would drive a coach and horses through the clawback regime, and it wouldn't. And again, I'll explain that in more detail in due course. But if you take a simple example, if the dividend was declared as part of a sale transaction, where on terms the buyer is required to recapitalise the purchased company in the amount of the dividend, so the company is left in a net neutral position, why should the court hold in those circumstances that the dividend is a transaction at an undervalue which requires to be justified under section 2385? We suggest it clearly wouldn't.
Can I make sure I've got that down? So if the dividend was declared as part of
A sale transaction where on terms the buyer is required to recapitalise the purchased company in the amount of the dividend, with the result that the company is left in a net neutral position, why should the court hold that on those facts the dividend is a transaction at an undervalue, disregarding the full picture, i.e. disregarding the recapitalisation obligation? The answer surely would be it isn't. The company is net neutral, there's been no extraction of value.
Well, it might be. If, for example, that term was in the agreement but was known to be incapable of performance. So there's it's very fact dependent.
Yes, I would accept that, my lord, of course.
I mean, that's why your point about the evidence being important is obviously has to be given careful attention. But it is 4:15, and so we're going to give that careful attention tomorrow. How long do you think you'll be?
I think, my lord, I will be the morning tomorrow.
The morning. I mean, so we should, with a fair wind, finish tomorrow with good luck.
Well, we'll finish on 1 and 2, depends a little bit on what more we're going to do on 3.
Yes, if we haven't had, yes, we'll finish on 1 and 2, yeah. And the first bit of 3.
And the first bit of 3, I think Mr. Hubbard will probably be 45 minutes. More like an hour, I'm told. More like an hour.
Right. Okay, well, we'll resume at 10:30.